The Second Amendment is pretty early on in our Bill of Rights. How was that interpreted historically in the United States?
Yeah, so of course the amendment became effective in 1791 at a time when the nature of the weaponry was far different from what we experienced.
This like flint, musket or something?
Yeah. If you look at the weaponry available in 1791, none of it could possibly lead to a mass shooting event. It took like 30 seconds to reload a musket. That would give plenty of time
to run out of the range of that musket.
Yeah, exactly. And the weaponry today, of course, as we mentioned with the Dayton shooter, is so potent that you can shoot 30 people in a matter of seconds. And so it is a different sort of problem. And
that's something that probably a lot of people don't know. We're talking about 30 people in a matter of seconds, not even minutes. These guns are incredibly powerful. They're sophisticated, and they're made for imposing harm, for imposing danger.
Yeah, so for example, the AR-15, which is sort of a weapon of choice of some of the mass shooters, was actually designed for combat use in Vietnam. And if you look at the Department of Defense descriptions of how effective it was as a killing machine, it really is quite astonishing.
Chilling.
To think what happens when a mass shooter gets his hands on such a weapon and uses it on a crowd of people, which is what a number of these mass shooters try to do. They get to, of course, the Las Vegas killing, up in a hotel, shooting down on people at a concert. It's a frightening thought.
From a long distance away.
Yeah, from a long distance away. So the capacity to stop that individual was limited, and his capacity to rain down terror was great. And in fact, even there we were lucky. He did manage to shoot almost 500 people, but if the police hadn't gotten in and stopped him, it could have even been worse.
And even there, am I mistaken, or did he take his own life?
Yeah, he ended up killing himself as the police were trying to break down the door into his hotel room.
Okay, so the Constitution may not have been able to anticipate advances in weapons technology, but it's pretty clear that the Constitution did anticipate a right for self-defense, a right of the people to bear arms.
Yeah, so the interesting question is the Constitution actually says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so for a long time there was a debate, does this Second Amendment confer a right for a state to have a militia, or is it a more personal right of self-defense and the right to have a gun for other lawful purposes? And for a couple of hundred years, the Supreme Court never explicitly addressed that issue, but in 2008, in the Heller opinion, the Supreme Court said it was a personal right and a right to self-defense within the home. And now the Supreme Court has taken a new case that might say it has a broader right beyond self-defense in the home to the right to carry in public. And so we're waiting to see what the next decision of the Supreme Court will be.